A routine arraignment quickly turns into a high-stakes felony hearing as Andre Smith Jr. faces accusations of fleeing police, causing a crash, and driving without a license. With a potential 5-year prison sentence on the table, every decision made in court will determine whether he keeps his freedom or loses it before trial.
My file, date of the offense, December 5, 2020. Place of the offense, I-94 Service Drive in Denton Roads in Van Buren Township. This is upon the complaint of Officer Valevska. Count 1 says that you were the driver of a motor vehicle to whom was given a visual or audible signal by hand, voice, emergency light, or siren by Officer Valevska, a police officer who was in uniform, and the officer's vehicle was identified as an official police vehicle. The officer was acting in lawful performance of his duty, directing you to bring your vehicle to a stop, and that you did willfully fail to obey that direction by increasing the speed of the motor vehicle or attempting to flee or elude the officer, and the violation resulted in a collision or an accident in an area where the speed limit was 35 miles per hour or less. This is a felony, sir. It is punishable by up to 5 years and or $1,000 fines plus court costs. Count 2 is a misdemeanor charge that you operated the motor vehicle without having in your immediate possession an operator's or chauffeur's license and did fail to display same upon the demand of the officer. This is a misdemeanor punishable by up to 90 days and or $100 fines plus court costs. Do you understand these charges, Mr. Smith?
Yes, sir.
I'm going to enter a not guilty plea for you. Your court date is going to be December 16th at 10:10 in the morning. The nice officer that's with you will give you a written notice to hang on to. Our case number for Mr. Smith is 20-1661. Sir, is your address on Hayden Street?
Yes, sir.
I've got a phone number, 772-5939. Is that accurate?
That's mine. Yes, sir.
And do you have an email address that you use?
Yeah, you can use the email. You ready for it?
Yep.
Andre Smith 123455 @gmail.com.
Thank you.
You have 2 civil infractions, Judge.
No, thanks. All right, I also understand you've got 2 civil infractions. We'll talk about those in just a minute.
Okay.
I have signed paperwork. There will be an attorney appointed to represent you for this December 16th court date if you do not or cannot hire your own attorney. I've got that contact information from you, and we will pass that on to the attorney so that attorney can reach out to you before the 16th. Do you understand all that?
Yes, sir.
All right, are you working, Mr. Smith?
Y'all do door-to-door sales for AT&T, door-to-door?
How long you been with AT&T?
Since January.
Debt payable to the court in the amount of $5,000 if you violate bond.
Yes.
You can put your hand down. On that file, do you have any questions about the procedure?
No, sir.
All right, and I've got 2.
Well, I actually got one question.
November 2nd. I'm sorry.
I actually do got one question. Well, it ain't a question, but I already do got a lawyer. So.
All right, that's fine. Then your lawyer will file paperwork with the court so we know that he or she is representing you.
Okay.
All right, so I've got 2 files here from November 2nd. One is a speeding ticket, one is no proof of insurance. These are civil infractions. Looks like you are in default on these with money due. 180 on the speeding, 270 on the no proof of insurance. Are you in a position to commit to some kind of payment plan, regular, weekly, bi-weekly, or monthly payments?
Is that Taylor, right?
I'm sorry?
It's Taylor, right?
No, Van Buren Township.
Yeah, because I actually had like.
This was at 275 in Tyler.
Yeah, I've been trying to pay him because I was able to pay Allen Park. They got that out the way. Taylor kept telling me to turn myself in, but I never really had the the guts to really turn myself in just yet, But I got the money I could pay today.
How do you want to pay it? You want to pay it all at once, or you want a payment plan?
All at once.
So I'll give you until this Friday to get it paid.
Okay, gotcha.
If you're going to do it in person, you have to be here before 2 o'clock. So between 9 a.m. and 2 p.m.
So tomorrow before 2.
That's fine.
I gotcha.
All right. Any questions about anything we've done?
Benefit of the doubt, assuming as true what this witness is saying, It's an A and B on a dog. It's assault and battery. He punched the dog. He didn't torture or kill or maim. So I don't even think by a probable cause standard that there's any justification for binding over on this 10-year felony, which would be comparable to the bind over on the GBH judge. I think that, quite frankly, on this record, it's a bit ridiculous. So I'm asking the court to decline to bind over on that. With regard to witness tampering or interference, judge, the claim was that my client called his own cell phone and that the witness picked up.
Well, he knew he wasn't calling himself.
He knew he wasn't calling himself. However, people can call their phones from jail for various reasons. I don't think that's speculative to see if your phone is still working, to see if it's operable, see who has access to it. Perhaps someone stole it, who knows? But all of that to say is her testimony was that he said, please don't move. Again, Judge, I don't even think it's a question of fact as to whether that rises to the level of witness tampering. This is not a situation of, nonstop phone calls, threats, or things of that nature. It's very sparse. And so for those reasons, Judge, I'm asking the court not to add those 2 counts. With regards to the remaining counts, we'll object to that argument.
All right, Mr. Leckie.
Briefly, when it comes to an animal, it's not just one party.
You can stop. You're not going to get me. You're not going to get me there.
And on the witness intimidation as itself, she did say there were multiple phone calls.
2. I think she said 2.
We didn't ask.
No, you're right. You're right.
We didn't ask how many there were.
Duchesne said 2.
But there are multiple. I know it's not on this record, but more than once where he's saying those statements. All it takes is once in this people's possession to effectuate some kind of tampering. He literally stated, don't come to court.
Do the jury instructions require any kind of a threatening language or intimidating language?
That's where I was at. They don't specifically say so, because there's multiple. I'm sorry.
Go ahead.
I'll give you a chance, counsel.
Instructions that involve there's interfering, there's intimidating, there's threatening. I am specifically going for interfering with witness intimidation, which specifically requires that intended to impede, interfere with, or prevent friction. I think
a begging phone call fits that definition, Mr. Polkowski. But I'll give you a chance to argue that.
I just, can you clarify which TACO you're relying on, just like the statute?
So it's technically MCL 750122, and then it's subsection 3, B and C, but the criminal jury instruction is 37.5.
Well, if we're looking at the plain language,
Attorney on these 2 comments.
people that represented, that they're pursuing it under subsection 3, and yes, that's required. A person shall not do any of the following by threat or intimidation. And discourage or attempt, etc. So if that's the language that the people are in fact relying on, no, I don't think there's been any evidence in this record concerning any threats or intimidation. So simply a statement, don't come to court, alone is insufficient to justify a binding over on this subsection statute.
And Judge, if I may, I'm referring to section B or C, which requires an influence or an attempt to influence or an encouragement or attempt to encourage.
And that's fair. It's predicated on a person shall not do any of the following by threat or intimidation. So, I mean, it's.
All right. Somebody bring me the language, because obviously you 2 aren't reading the same thing. No, I don't mind. Yeah. Or just give me the number. I got the jury instructions right here.
It's 750, or I don't know.
Okay, I'll find.
I just had the jury instruction.
750.
Hold on. He's got it on paper. I love paper.
I know, Judge. That's why I always have to be clear.
Well, but does that clarify that it's under subsection 3?
So
It doesn't.
It says criminal jury instruction 37.5A, interfering with witness.
this is the section.
Yes, but now for purposes of the information, if his basis and my client titles.
Code is generally just 122. It doesn't go into that, but I'm referring
To, right, and so the actual language of the statute, to be clear, says a person shall not do any of the following by threat or intimidation. Do we agree on that? in subsection 3. Yes.
So the statute requires we start with threat or intimidation 2, and then
Correct.
options what they're trying to do with the threat or intimidation.
Correct.
Mr.
And then the
Lecky-
options include candidly.
Hold on. Mr. Lecky, you agree that that's the way the statute reads?
I'll agree, and I'll also include that intimidating behaviors.
The hearing reaches a critical turning point when the judge rejects the defense's arguments and allows the prosecution's case to move forward. In a calm but decisive ruling, the court signals that the evidence is strong enough to continue, shifting the momentum firmly in the prosecution's favor.
As requested by the prosecution, AOI date is next week at 9 a.m. Anything as to bond?
No.
Well,
12/3. That's the AOI, 12/3. What'd I say? Okay. Anything else? Good luck downtown, Mr. Roche.
oh, it's not good. But briefly, just
Go ahead.
like the defendant's own privileges to be revoked or released. His number and the explaining witness Heather and Valerie.
Do we have the ability to just block numbers? Then I will order that his number be blocked.
Both the victims.
Well, Heather said twice that he didn't know her number. So, and there's no allegation he called anybody else improperly. Would you provide, you got it. You're all right. We don't need statute numbers. We just added the domestic. We're all right. Yep.
Yes, he does, to my surprise. He wasn't drunk. He was drinking. There's a difference.
Okay, so with your testimony, he actually wasn't drunk.
No, my testimony is he was drinking alcohol.
Okay, but you just testified that he was slurring his speech.
When did I say that?
About a minute ago, we can have the court reporter read back. So is it you retracting that statement? He wasn't slurring his speech?
I don't recall saying he was slurring his speech.
Okay.
I said that he was drinking.
Okay. Now, you testified that at some point, he, as in Mr. Roche, had both of you by the neck.
Yes.
Okay, where were you in the living room?
On a love seat.
So you were sitting down on a love seat.
Well, she was sitting on the love seat, and I came to pull him off, and he flipped me this way. I was standing beside him this way with my back here, and he flipped
Okay.
me this way.
Let me break this down. Heather is sitting on the love seat.
Yes.
You are not sitting on the love seat.
Not yet.
Okay. Then at some point you come to sit on the love seat.
No, I get thrown onto the love seat.
Okay. At some point, your bottom is on the love seat.
Yes.
And that's the point at which he has both of his hands on each of your necks.
Yes.
And then he lets go.
After us fighting them off, yes.
Okay. And then he leaves the room, right?
Well, the difference between our room and the kitchen is open is between here and there
He walks away from you and Heather.
for the first time.
Ma'am, just answer the damned questions.
The courtroom turns intense. The defense challenges every claim, trying to break the story apart. But the judge remains cold and controlled. Then suddenly he interrupts, cutting through arguments with authority. This is where the entire case starts shifting.
No, it was 45 minutes.
Okay. So 45 minutes later, the police arrive.
Not even 45 minutes.
So fair to say you spoke with the police that evening.
And what?
You talked to the police that evening, fair to say?
Yes, I did.
And hang on, I'm going to ask you the questions here. Did you call 911 or did somebody else call 911?
Heather called 911 and then I called 911.
So there should be 2 calls to 911.
Yes, there is.
Okay, and ultimately, I think a handful of officers arrived. 2 or 3 officers,
3 officers, 2 paramedics.
and they arrest Mr. Roche.
Yes,
And then you and Heather are giving statements to the officers, right?
separately, yes.
Well, in fact, you and Heather are both seated in the living room while you're talking to the officers about what happened. No.
Actually, they separated us.
Okay. And if I were to
Don't
use body
see me on
camera showing that you and Heather were in the same room, that footage would be not that sound real.
We were in the same room, but when they were questioning up, like doing the witness statement, no.
Oh, and you give a written statement to them?
Yes,
Okay, and you signed that statement?
yes.
Now, after that evening, did you ever come into contact with the police again about this case, to talk about this case?
Only on the phone.
Okay, and can I ask, who did you speak with on the phone?
I cannot tell you the officer's name.
Okay, but you did talk to an officer on the phone. And when was that conversation? If you remember,
Years after that,
a couple days after?
yeah, the meeting just happened.
Okay, and then you also spoke with, the prosecutor, and you spoke with this officer, Officer Rice. And when you had this conversation with, let's start with, Detective Rice, was Heather there with you?
No,
And when you had a conversation with, Prosecutor Leckie, was Heather there with you?
no,
And when you spoke over the phone to whichever other Romulus PD or Van Buren PD, the Romulus?
Romulus.
Yeah. You spoke with them on your own?
Yes.
Just a moment there. I have no further questions.
Mr. Leckie,
Nothing further, Judge.
ma'am, you can step down, watch your step on my ramp. Next witness. Who's gonna get Heather?
Margaret Malpique.
Miss Crowell, all the way up front.
Okay.
Miss Crowell, raise your right hand. Swear or affirm, tell the truth, the whole truth, and nothing but the truth today? Come on up here. Watch your step on this incline ramp. Settle in that chair. When you're ready, Mr. Leckie.
Good afternoon, Doctor. Now, I'm going to ask you to speak in this microphone. It's a recording microphone, and right? Yes. So, I'm going to ask you first to state and tell your name.
So my name, HGACSGR,
And do you know Mr. Sean is he here for? How do you know? Okay. So, what's your role to be? And then, based on your statement of he's wearing the pink shirt, I'm going to ask the record reflect the misstatement.
Noted.
So, were you heading 601 West Maple, around Michigan, 11-3, and were you there? Now, I understand there's a point in time in which, the defendant came in contact with you in that case, if you were on the low seas, right? Okay, tell us what happened.
he walked through the door, like he called. He was just sitting next to me, sitting there, and I told him, I said, Sean, we don't have families that can save me. I don't know what was that on home. He ended up. He. Like. What's for me? Take that off.
Let's stop you just there. Take a second, I'm gonna ask another question, right? So you said his hands were around your neck, correct? Like this. So you're indicating both of his hands, correct? Okay. When he was showing you, did you have struggle breathing?
I couldn't yell, I couldn't scream. The only
No. I know you're finding your elbow, and then you just speak right in that. A little or anything.
I was sorry, so bad.
And And so, now you mentioned valid, who's that?
Family is not allowed.
The court orders the case to proceed to the next stage while leaving the defendant's bond in place under strict conditions. Additional protective measures are imposed to prevent further contact with the alleged victims, reinforcing that any violation could have immediate legal consequences. The hearing ends with a clear message: the case is far from over, and every future court appearance now carries even greater weight.